Good morning. My name is Lauren Eversole, and I'm a staff attorney with Disability Rights Florida. I work on the Advocacy Education Outreach team. I'm going to introduce my boss, my supervising attorney, Ann Siegel, who's in the room with us today. And today we're going to talk about access beyond the classroom. I know that there's a lot of focus on the school day, but what we've been seeing and what there's the trend of a lot of students with disabilities being excluded from programs beyond the school day, and I wanted to talk about ways that we can advocate for children to ensure that they do have equal access to those programs, and we'll get into it here. Disability Rights Florida, our funding, responsibility, and authority is under 9 federal programs to protect the rights of Floridians with disabilities. We're a not-for-profit corporation since 1987. We have offices in Tallahassee. I'm in the Tallahassee office, Tampa, Hollywood, and Gainesville. And we have some satellite offices in other communities. And our mission is to advance the quality of life, dignity, equality, self-determination, and freedom of choice of persons with disabilities through collaboration, education, advocacy, as well as legal and legislative strategies. A little bit about me. I've been with Disability Rights Florida since 2016. I have an MSW in addition to a JD. I'm originally from North Carolina, so not a native Floridian. And I work primarily with students with disabilities, ensuring that they have a free and appropriate public education. And I also do some, I do community accessibility and work with students who are trying to access post-secondary accommodations. So our team is kind of community, we just try to ensure that people in the community have access to community services programs, education. That's what our team primarily focuses on. So today we'll cover applicable laws, regulations, and guidance that govern accessibility to activities for children with disabilities beyond the school day. We'll look at case examples and talk about advocacy and legal strategies and go through some hypotheticals. Cue the flashbacks to law school, I apologize. So what are activities beyond the school day? We're talking about extracurricular activities, things that we know basically, like field trips, athletics, student organizations, clubs, chorus, band, drama, just a few examples. Also school-based before and after school programs. That's usually to provide, childcare and, non-structured academic support to students. And also community-based programs, like, your recreational sports, summer camps, like Little League, things like that. We'll get into more detail. And this is pretty intuitive, and there's a consensus among researchers. The benefits of extracurricular and after-school activities, improve academic performance, students have lower dropout rates, increased opportunity for socialization with peers, increased self-esteem and sense of belonging. There's also safety and supervision provided, definitely with these after-school programs that we'll be discussing. Structured academic support, exposure to new interests, and it always, it helps college applications and resumes. And the benefits of inclusion for students with disabilities, it's mutually beneficial to students with disabilities and also students without disabilities. It provides opportunities for children with disabilities to develop social and communication skills. They can, some students with disabilities have, limited communication skills. Being around other students who can model that for them is beneficial. Increased contact with peers without disability will help prepare for life after school and an inclusive society, hopefully. And children without disabilities will have the opportunity to learn and appreciate diversity and prepare for life in an inclusive society. And it's just an opportunity for everyone to build and maintain friendships. So the legal authority that applies to this area. We have the Individuals with Disabilities Education Act. How many of you heard of that? Okay. Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. And there are titles within the ADA. Title II applies to state and local governments. Title III applies to public accommodations. And so, brief overview of the IDEA. It makes available a free, appropriate public education to eligible children with disabilities throughout the nation, ensures special education and related services to those children. And in order to be eligible for special education under the IDEA, you have to meet certain categories of disability and have them listed here. Yes.
Is it validated by what agencies, like medical?
Okay. The schools do, actually. These are what we would call an educational diagnosis. So the schools, if a child has a suspected disability, the school has the obligation to evaluate these students or the child. And in all areas of suspected disability, they have to provide comprehensive evaluations, and they can go through, or the school has to go through these categories to see. There's certain criteria under each one of these categories. And if the student based on the evaluations meet these criteria, then they have show a need for specially designed instruction, then they meet the requirements to be. Yes, the eligibility category is, yes, definitely. But one thing to remember, if you, regardless of your diagnosis, your educational diagnosis on your IEP, the student's needs drive the services. So for instance, if you have a learning disability, but you're having behavioral issues in school, just because you're not labeled emotional behavioral with an emotional behavioral disability does not mean that the school doesn't have to provide behavioral services. That no matter what your diagnosis is, your needs drive. So as long as you're eligible under one of these categories and you meet the criteria, the school's obligated to meet your needs. So the IDEA and its implementing regulations mandates that school districts take steps, including the provision of supplementary aids and services determined appropriate and necessary to afford children with disabilities an equal opportunity for participation in those services and activities. The regulation here, it defines non-academic and extracurricular activities to include counseling services, athletics, transportation, health services, recreational activities, special interest groups or clubs sponsored by the public agency, and this list is not exhausted. So we're not limited to just these categories. So the IEP must include any supplementary aids and services that the student will need to participate in the activity. And according to case law, there's nothing in the IDEA regulations that requires IEP teams to exclude non-academic activities from a student's IEP because they are not required to educate the student. And the court found in this case the district violated the IDEA by refusing to consider supplemental aids and services requested by a student's parents to enable her to participate in after-school sports clubs. So in this case, the student was diagnosed with autism spectrum disorder and Tourette's syndrome. And she was, I think she was trying to participate in volleyball, and the parents requested, certain accommodations, like allowing her to miss practices, allowing her to miss some games, and having adult supervision with her after the activities to ensure, her safety until someone could pick her up. And the school pretty much told the parents, sorry, that's more of a Section 504 issue, which we'll get to. That's not something that we can put on her IEP. That's not something we can do under the IDEA. And the court said, no, yes, you do. So you have some examples of supplementary aids and services. I mean, there's so many, and you can be creative as you want to be to meet the individual needs of the student. But I just put some examples up here, well, based on case law. In one instance, the district's failure to provide a qualified interpreter for a deaf student during football practice, as provided in the student's IEP, violated the IDEA and denied the student an equal opportunity to participate as a football team manager. And for behavioral supports, which is a huge issue, I know, with a lot of our clients, the district's failure to provide appropriate behavioral supports to a child that was excluded from attending a good behavior field trip due to ongoing behavioral issues within the classroom amounted to a denial of FAPE, free and appropriate public education. Of course, there are some limitations to the IDEA. A district may place reasonable limits on the participation of extracurricular activities for safety reasons. And this is just an example. A student with a visual impairment was not denied a free and appropriate public education when his band leader placed him in the flute section rather than the saxophone section. They were alleging that he was being treated differently, but this is to minimize the risk of collision with other members of the band. And also, a student with severe behavioral concerns was not improperly excluded from non-academic activities. But what I would suggest is, always go back to the IEP team and make sure that there are appropriate behavioral supports and services in place. If you have a child with behavioral concerns that's inhibiting him or her from participating in these activities, investigate whether or not this child has had a functional behavioral assessment and a behavior intervention plan, because that can always, be used and modified to use, for these extracurricular activities. Sometimes in these programs, extracurricular programs, they're unstructured compared to the classroom environment, and so maybe more behaviors would manifest in these settings. And so I definitely think that it's appropriate, as an IEP team to, even though it's, maybe the child's behavior is manifesting during the after-school activity, but not during the school day, but it's definitely appropriate for the team to address these behavioral concerns to enable this, to enable a child to participate. So that's just my advice. So we'll move to Section 504 and Title II of the ADA. Section 504 is a federal law that prohibits any entity that receives federal financial assistance, which would be school districts, from discriminating against persons with disabilities. And Title II of the ADA is a federal law that prohibits state and local governments from discriminating against persons with disabilities. Both, in general, apply to school districts. And a person with a disability means a person with a physical or mental impairment that substantially limits a major life activity, has a record of such an impairment, or is regarded as having such an impairment. And the determination of whether a student has a physical or mental impairment that substantially limits a major life activity must be made on a case-by-case basis. And Section 504 in the ADA must be viewed to provide broad coverage of individuals. So this is useful because if you have a child that isn't, eligible under the IDEA, these laws capture a wider, amount of kids that could possibly qualify for accommodations and services under 504 in the ADA. So Section 504, like we discussed with the IDEA, requires school districts provide non-academic and extracurricular services to and activities in such a manner as is necessary to afford disabled students an equal opportunity to participate. And Title II requires public entities to make reasonable modifications to policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service, program, or activity. And this This applies to non-academic and extracurricular activities operated by school districts. OCR, who is responsible for enforcing Section 504 in Title II, issued a guidance clarifying the existing obligations of school districts to provide students with disabilities an equal opportunity to participate in extracurricular athletics, which I would argue would not just apply to athletics, but also other activities, extracurricular activities. So school district must not exclude students based on stereotypes and assumptions. And the guidance gives an example of a student with ADHD or learning disability who makes an athletic team, but the coach is concerned about the student's ability to work under time constraints and pressures, and never puts her in a game, which would likely be a violation. It would be discriminatory treatment. And school districts must make an individualized inquiry to determine if there are reasonable modifications or necessary aids and services which would allow a student with a disability the chance to participate in the activity. So we have some examples that OCR provides. Using a light along with a starter pistol so that a runner with a hearing impairment can compete in track. Are providing for or assisting with the administration of needed medicine like insulin so that a student with diabetes can take part in an after-school gymnastics club. And this also applies to like overnight trips and trips outside of the school district. So it's not just, some school districts will say, oh, well, that's not our responsibility. Maybe the parent should go with you, with the student to provide all these things. But no, they can't do that. I mean, a parent can go if they choose, but they can't require the parent to provide those services. Of course, there's some limitations. The requirement to provide equal opportunity does not mean changing essential elements that affect the fundamental nature of the game, giving a student with a disability an unfair advantage over other competitors, changing the nature of selective teams. Students with disabilities have to compete with everyone else and legitimately earn their place on the team, or compromising student safety. And this guidance also mentions that there's not an obligation for schools to provide like separate teams for students with disabilities. I mean, nothing's preventing them from doing that, but well, that could also be kind of a discriminatory concern if they're sending them to the separate teams and not giving them the opportunity. But again, there's no obligation that, for instance, the school would have to provide like wheelchair basketball or something like that. The guidance also notes that a school district would need not provide a modification, aid, or service if doing so would put an undue burden on its program. But this is interesting. Most cases, OCR believes that providing reasonable modifications and necessary aids and services should not be unduly burdensome for school districts. So they kind of have a high hurdle to jump over to prove that it would be burdensome. School districts do. So we'll move into before and after school programs, and this is what kind of led me to look into this issue more, because we've had a lot of cases of kids getting kicked out of after school programs, primarily for behavioral issues. Section 504 and Title II of the ADA cover before and after school programs run by school districts. And then they also apply to district-sponsored programs. And in order to determine if the program is district-sponsored, the OCR will look at factors that connect the district to the program, such as direct or indirect financial support, such as providing the staff or paying for the staff who run the program, providing facilities rent-free, using the district's website to advertise, following district policies and administering the program. And I mean, of course, probably the more factors you have here, the stronger your case is. So, the applicable regulation states that no qualified individual with a disability shall, on the basis of disability, be excluded from participation in be denied the benefits of or otherwise be subjected to discrimination under any program or activity which receives federal or financial assistance from the department. And let's see. And the regulation implementing Section 504 provides that a recipient that provides daycare may not, on the basis of disability, exclude qualified persons with disabilities and shall take into account the needs of such persons in determining the aid, benefits, or services to be provided. And there has to be an individualized inquiry. They can't base it on disability, the disability category. I know you keep seeing the word qualified. Typically, qualified individual just like in this situation means, a student that would meet the essential eligibility requirements to participate in a program. So, and I've read cases from OCR pretty much, if this program is something that's provided to students in A district, then a student in A district, or B district, is a qualified person with a disability who's able to participate. So the threshold's pretty low for that to be considered a qualified person. I think I went over that. Pursuant to OCR policy, children with disabilities may not be categorically excluded from these programs. So they can't say, children with XYZ disability can't participate. It has to be the main goal or concern is making sure that regardless of the category of disability, we're looking at this child as an individual with a disability, looking at this child's individual needs, and how can we accommodate those individual needs. Just kind of like what I mentioned before about going on field trips or overnight trips, OCR policy further provides that parents of children with disabilities may not be required to provide their own aides and babysitters to care for their children, where the parents of non-disabled children are not subject to the same requirement, and they can't be charged more than parents of non-disabled children. That would be a surcharge. So the ADA provides for reasonable accommodations for students with disabilities, and a public entity is required to make a reasonable modification in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service or program or activity. And the regulation implementing the ADA does not require a public entity to take any action that it can demonstrate would result in a fundamental alteration of the nature of a service, program, or activity. I'm not going to read all that, but essentially these public entities have the burden of proving that that the accommodation that they provide would be a fundamental alteration or an undue burden. And they're actually supposed to provide a written statement of the reasons for reaching their conclusion if they deem an accommodation as an undue burden or fundamental alteration. But pursuant to OCR policy, the law is very clear, the policy is very clear that providing additional supervision in a daycare program, such as a one-to-one aid, will not ordinarily change the fundamental nature of a program that is designed to provide supervision for children. They're getting into undue burden. Okay, so it doesn't require a public agency to take any action that can demonstrate will be an undue burden, which is defined as an action requiring significant difficulty or expense. And we have some factors here, the nature and cost of the accommodations, the overall financial resources of the facility, and the number of persons employed at such facility. Just with school districts, again, it's a high hurdle for them to overcome, to say that they don't have the resources. It was kind of like what I was talking about before. We'll skip through that. Also, ADA prohibits a public entity from placing a surcharge on a particular individual with a disability or any group of individuals with disabilities to cover the cost of measures such as the provision of auxiliary aids or program accessibility that are required to provide that individual or group with non-discriminatory treatment. Providing extra supervision, again, to a child with a disability ordinarily would not be or unduly burden a recipient. So OCR doesn't view providing extra supervision to a child as an undue burden or a fundamental alteration. And again, same with fundamental alteration. The undue burden has to be accompanied by a written statement of the reasons for reaching that conclusion. Here's some examples of reasonable accommodations for children in after-school programs. We can look at a behavioral plan, a reward system for children with behavioral concerns, a one-to-one aid for children with behavioral concerns or complex medical needs. And here's an example from Alachua County. The district denied a student equal participation in its after-school program by failing to provide any services for his colostomy bag while he attended. It's pretty clear here. Consider services that can be, okay, so Florida has a statute where you, administration of medication, this is a statute, administration of medication and provision of medical services by district school board personnel. You know, a lot of these services can be delegated to non-medical personnel as long as they're provided with child-specific training by qualified medical personnel. So if they try to tell you, oh, well, you know, I don't know, to change a colostomy bag or to provide insulin or whatever, oh, we have to have a nurse and we don't have a nurse on staff. Don't buy that. Check out this statute to see what kinds of medical services can be provided to non-medical personnel, and it's a lot. Like, I mean, it's more than you would think. As long as they're trained, that's another thing. Make sure, and also I had a situation where the school required the parent to provide training instead of providing a nurse to provide training to school staff, which, I mean, it's fine for her to participate and to give guidance, but it's not her responsibility. It's not the parent's responsibility. So limitations to Section 504 and Title II of the ADA. If the student poses a direct threat, then that could be a basis for excluding the student. But they have to, programs have to make an individualized assessment and consider factors such as the nature, duration, severity of the risk, the probability that the potential injury will actually occur, and whether reasonable modifications of policies, practices, or procedures will mitigate the risk. So, I mean, you know, clear example of that would be a student with behavioral concerns, you know, in an unstructured environment may need a one-to-one aid to mitigate those behaviors and to ensure safety, and they should provide it. School districts should provide it. Yeah? I know. I know. Yeah.
I think you look at past behaviors, past incidents, things like that, and we can never predict that 100%.
No.
We do that in the law a lot. We look at the surrounding factors and say, like, can we make a best?
Mm-hmm.
Yes. But I think the point would be too, are there different services?
Right. To mitigate that risk. Right. Yeah, that's very, very good. Thank you for, yeah, that's a very good point. Yeah, that's definitely, that's something that is so important to, you know, look at, you know, what can we put in place to meet the child's needs so that they can access the program. If they have I don't know, if they are having behaviors in the classroom, looking, that would be a predictor, I guess. Like how would this student generalize the skills from the classroom that he's learning to manage his behavior to an after-school setting? There may be concern that in an unstructured environment, his behaviors would manifest or her behaviors would manifest. But, looking at what can we do, and, do we need extra pair of eyes, extra pair of hands there?
I think the parent will tell you, he used to really struggle, but we've seen that, as he's gotten older, he's doing better, he's successfully participated in this activity. Do you know what I mean? Like, I think it could go either way. You just kind of have to
Yeah. Yeah, and data is important. Schools should be collecting data to determine if there's an improvement in behaviors. You have a question?
Sorry. Yeah, have you seen where they'll say they're a direct threat in one particular circumstance and they're trying to continue saying this child is a direct threat due to previous behavior, but it's a completely different situation? Maybe there was a trigger and in this situation there isn't. Has that ever been worked through?
Yeah, and it's very case by case specific, very fact specific. I know that's a very lawyerly answer. It's not a good answer, but yeah, all children are different and their behaviors manifest in different ways regardless of their disability. So I don't know if you have anything to add, but I just, looking at it on a case by case basis. Go ahead.
Yeah, oh my goodness. I'll hold that down here. So so we've had numerous issues where they try to exclude kids because of a basis of, they did X, but that was without the use of supplementary aids and services. So you do have to distinguish, as she said, what mitigating factors were. The child wasn't provided the appropriate services, but with the appropriate services, we've seen a decrease in that behavior and things like that. Oftentimes, what we're finding is that agencies or schools and stuff are trying to get our kids to earn their way in, and they don't understand they have a right to access.
Right.
It's not a mother may I kind of situation.
Yeah, I'm seeing there's like a child that's been to like a fire station to see like the firefighters and stuff, and they have a sensory issue like the lights and then they're afraid they're going to have a certain kind of temporarily they're going to have this issue on the next trip. So they're like, no. Well, it's a different kind of trip. They're not going someplace where there's lights, there's sirens, there's a lot of things that would cause the child. So we're just kind of wondering if maybe that would be something that we could try to push.
Yes, and the thing, and absolutely, and to just say, well, you had trouble on that because of your disability, you can't go anywhere else, is discriminatory. So what we do is, look for what the triggers were. Was it over, sensory issues? How do we address those for the next trip? Because the whole goal that seems to be lost somewhere is integration in the community and making our children as independent as they can be, and they're not going to live in a separate, segregated world. We're not trying to set people up for institutional living. The whole push and the whole goal is for inclusive living. So the more access that they have to these situations, the more independent they're going to be. And I think that's really what people get kind of bogged down in, and they lose that message with these federal laws that are there to protect and to give access.
Thank you. So we've been talking about school districts, but then there's also extracurricular activities provided by other public agencies and private agencies or entities. And those are your municipal sports activities, summer camps, privately run child care centers, and religious-based programs. I started that for a reason. We'll get to it. Let's see. So applicable laws to non-school district programs. Title II still applies to these programs because they apply to any public entities that are run by the state or local government, any department, agency, special purpose district, or other instrumentality of a state or local government. So Title II is intended to apply to all programs, activities, and services provided or operated by state and local government. Section 504 of the Rehab Act only applies to programs or activities receiving federal financial assistance like school districts. So because many state and local government operations such as courts, licensing, legislative facilities, and proceedings do not receive federal funds, and they are beyond the reach of Section 504, but Title II still applies. So is it a public entity? Where an entity has both public and private features, it is necessary to examine the relationship between the entity and the governmental unit to determine whether the entity is public or private. There are certain factors to consider, whether the entity is operated with public funds, whether the entity's employees are considered government employees, whether the entity receives significant assistance from the government by provision of property or equipment, and whether the entity is governed by an independent board selected by members of a private organization or a board elected by the voters or appointed by elected officials. And I'm sure this is not exhaustive. These are just examples and factors for you to consider. This is an example of a government entity running a program for children. The town of Rocky Hill, Connecticut, refused to admit children using insulin pumps to a town-operated parks and recreation program. And the DOJ, who is responsible for enforcing Titles II and Title III, awarded compensation to the complainants and entered into a settlement decree or settlement agreement. That's just an example of a government public agency providing programs to children. Title III of the ADA applies to places of public accommodation, commercial facilities. The obligations of Title III only extend to private entities. I know I keep going at this over and over again, but it can get confusing. So state and local government entities are public entities covered by Title II, not Title III. So we have examples: privately run summer camps, child care programs, and recreational activities. But under Title III, these programs must not discriminate against persons with disabilities on the basis of disability and provide an equal opportunity to participate. You can't exclude children with disabilities from their programs unless their presence, again, would pose a direct threat. So there's a limitation to the health or safety of others, or require fundamental alteration or undue burden. They must make reasonable modifications to their policies and practices to integrate children, parents, and guardians with disabilities into their programs. And must provide appropriate auxiliary aids and services needed for effective communication with children with disabilities. So like interpreters would be an example.
If I may, if you have a school which is private, are they able to discriminate? Excuse me. If you have a school which is private, are they able to discriminate if they don't receive any funding from the federal government?
And correct me if I'm wrong, Ann, but Title III would apply to private schools if they don't receive any funding, or if they're not affiliated with any government program, so they would still have an obligation to. Now, the extent maybe not would be as stringent as under Title II or Section 504, but yeah, I would say Title III would apply to private schools. So
Even if it's for their own students, no public accommodation?
I'm sorry.
Even if it's only for their own students and it's not for anybody else? For their own private students?
For your own students. I mean, I would think that, anyone could try to access a private school. I mean, whether or not the private school would admit the student, that's, up to their determination. But I would say, yeah, Title III would apply to private schools. And if you have any, I'm going to defer to.
The problem with private schools is you're contracting for services, because they can't say, and they're not going to tell you, we're not accepting your student because of X disability. They'll do something, we feel that their needs could be, or they don't meet our criteria.
Yeah.
So it's not the same as a public program where they'd have it. So, we've at least discovered in ours is they don't come out and say that there is this reason. One of the things that you do when you're looking at a private school is check and see if there's any federal funding. It could be as small as something going to a library fund or anything to see, so you have a stronger nexus to, these laws. But I will tell you, in practice, and I've been doing this for about 20 years, I tend to shy away from the private placements because oftentimes they promise the sun, the moon, and the stars, and at the end it's just a matter of we have greater protections with public programming, and that's where we, IDEA follows and things like that. So while the ADA is there and it's an access law, the problem is we don't find it as a stronger tool, I guess, for lack of a better term. So I'm much more of a proponent of looking at public entities. Although, again, like I said, they're not to discriminate, but they don't come right out and say that they're doing it. And then you have to prove that that's really what they're doing. And usually, yes, I was going to say it's not an easy road.
And religious-based programs, there are a lot of those out there. The programs actually run by religious entities are not covered by Title III, but programs not actually run by the religious organization but are operating on the premises of a religious organization are generally not exempt from Title III. So here's just an example. If a private child care program is operated out of a church, pays rent to the church, and has no other connection to the church, the program has to comply with Title III, but the church does not. So here's some advocacy strategies that I listed. You can always start out by contacting the director of the after-school program or the director of the school district and try to negotiate services for your client. You can request records, like typically what I do. Well, especially for after-school issues, like I'll request disciplinary records. Usually they'll have those. They'll have write-ups, and you'll see a pattern of the student being written up before being excluded, and usually from there you'll know. I mean, there hasn't been a plan or anything put in place, or they haven't attempted to accommodate the student. But yeah, you can always start out with the lowest level possible and let them know, hey, there are these obligations that you have, and please let my client back in. Let's sit down and meet. Let's have a discussion about what we can do to meet this student's needs, provide reasonable accommodations, request any denials in writing. And actually, like we talked about before, they actually have school districts have an obligation to provide you with their reasoning for denying an accommodation in writing. Each school district has 504 grievance procedures, and that's another avenue that you could take. I would contact the District 504 coordinator. Sometimes you can find it on their websites, but it may just be easier to contact the 504 coordinator. If a student is eligible for an IEP, there's a state complaint process that you can file with the Florida Department of Education, and the Bureau of Exceptional Student Education will review the complaint. What they're charged with doing is investigating the complaint. They have 60 days to investigate and make findings, but often the state complaint process leads to a mediation or a bureau facilitated resolution before we get to the findings part, or before we get to them making any findings or ordering anything. It provides an opportunity for the parties to resolve it amicably. There's also an OCR complaint for violations of Section 504 in Title II of the ADA. And DOJ would cover Title II and Title III. When you're not talking about school districts, any other entities, Title II like I said, covers state and local government, but that would go to you would go through the DOJ for that, and also for Title III. And there's also the due process avenue. You can file due process under the IDEA and also under Section 504. It would be, Section 504 impartial hearing would be different from the grievance procedure. It's a little more formal of a process where the school district would contract with an impartial hearing officer, or school districts typically they contract with the Division of Administrative Hearings for IDEA claims. Some school districts will also contract with DOA for Section 504, but some won't, and so they'll have their own procedure for Section 504, or they'll contract with another entity other than DOA. So just ask their, general counsel or the district ESC director when you're dealing with Section 504, what procedures do you have in place for an impartial hearing, because it differs. So I have some hypotheticals, reminding you of law school again. Hypothetical one, a local hospital provides and administers a summer camp program for children called Fun in the Sun. The summer camp is generally scheduled for 8 weeks in the summer. Camp activities include games, sports, crafts, swimming, and field trips. The parents of a child with type 1 diabetes who needs constant glucose monitoring and insulin administration sought to enroll her in the camp. The camp refused to enroll the child in the camp, stating that it does not have a nurse available to provide medical services, and the mother of the child has to take FMLA to care for her child over the summer as a result. Anyone want to jump in, or what rule would apply to this fact pattern?
Florida statute that includes somebody. You mentioned the Florida statute that you could train somebody that is not a medical personnel just to apply the insulin to the child. And as far as I don't think the mother has to attend a special course. That's like I don't know. I don't think that's appropriate. That's what the school should do, it seems to me.
Yeah, and it's a local hospital, so actually this is based off of a DOJ settlement agreement, and so Title III applied in this case. So the settlement agreement pretty much provided for the hospital to modify its policies and provide mandatory training, to camp employees and restore the mother's FMLA. The mother actually worked for the hospital, so she had her FMLA restored. But yeah, this screams discriminatory. And really looking at the program, would it be a fundamental alteration or undue burden in this situation to provide someone to, provide insulin to the child? Probably. Oh, the Family Medical Leave Act. So, yeah. So she pretty much had to take, her, yeah.
I find it ironic that it's a hospital sponsored.
Yeah. Yeah, this is a real case. Yeah.
That just doesn't connect with just generally, what I mean?
Yeah. Yeah, this is based on a real case. Hypothetical to
I had a question about the previous
sure.
one.
Sure.
With diabetes, doesn't it also depend on the age of the child? Because one of the things we do with a chronic illness like that is teach the child or the person
Right.
to take care of themselves.
Right.
So at most, you might just need someone to check, yes, it's 15 units and blah, 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 and fine, and the child administers it himself. So it's like...
Yeah, that's definitely a factor. And, I had a situation one time with a child that it wasn't, he had diabetes, but also had to have Solu-Cordoff injections in case, he was injured or something. Even though he could self-administer, he was older. He was high school age. once he went into shock like that, he got into that state, like there was no way that he could self-administer, and it's strange with the Solucorda injections, like most local emergency agencies don't have Solucorda, or actually pretty much all of them don't, or even if a child like self-carries, some won't even administer it. Some will administer it if the child self-carries. So it's like, in that situation, it'd be so important to have someone, even though the child is old enough, the child may be in a situation, and perhaps with diabetes, I don't know, it could be child specific. Maybe the child's diabetes manifests in a way if something happens so fast and there has to be someone there. So yes, definitely age is a factor, but I wouldn't put everything into that. But ultimately, we are trying to teach children to become independent, as adults, because they're going to go off to college and live independently, and they're not going to have someone there all the time. But until then, it's the school's responsibility. I don't know if did you have anything to add in? I thought that you. Oh.
We've had situations, and you're right, we've had kindergartners where they haven't learned to count, so obviously they're not going to be able to do self-administration. But we've actually had a couple of issues with this in the school, in aftercare programs, and in summer camps that have addressed this, and they've had to provide somebody to assist the child in administering, and they were not allowed to tell the kid, you can't attend because you have. And it is kind of ironic with the last scenario she used. Sometimes we find groups that you think would have a much more heightened awareness about disability rights are oftentimes the ones who stumble the greatest in administering accommodations.
Okay, this one goes more to extracurricular activities. So a child in Sunshine School District with an IEP for speech and language impairment is nonverbal and uses an assistive technology device to communicate with others. The child knows some ASL, American or Sign Language, and wishes to participate in chorus with his friends. What do we think about this? We could, okay, go ahead.
So would that be covered under Title II? Because it is I'm sorry. Will that be covered under Title II, but it could, because it is a school district sponsored or run activity,
Right.
Therefore the child would have rights to participate based off of that?
Yes, definitely. It would be covered under Section 504 and Title II, because those apply to school districts because they receive federal funding, school districts do. And also because the child has an IEP, we can also use the IEP as a tool to ensure that this child has equal access. And actually, this comes from like a real life scenario. We advocated for an aide who knew ASL to attend the chorus classroom, the chorus class with the child to interpret the songs and teach the child the songs in sign language so that the child could participate, with his peers for the, assemblies and the concerts. But I just kind of put this up here as kind of like an example of, maybe a school district would look at this like, what do you mean he wants to participate in chorus? He's nonverbal. Like, what? But to me, you have to be creative, and think of other ways to enable this child. You can't base a child's participation on stereotypes. So. Yeah. But even if the child, even if the child didn't have an IEP, same thing. You could look at section. That's an alternative. You could look at Section 504 or in Title II, and under those rules, they'd be required to provide accommodations and services to enable. Go ahead.
I'm just going to be the fly in the ointment. Since the purpose of chorus is to provide a hearing verbalization of music, is it not an actual change of the integrity of the program? I mean, did anyone try and argue that? I mean, I don't.
I thought about that. I did. I thought about what you said, because it's like, would it be considered a fundamental alteration? But
Exactly.
you could argue, I mean, that's an argument, but no, I would say that my boss is like, no. But I mean, he's able to participate, he's able to convey meaning through, that's one
I
way
was
to
just
argue.
curious whether or not
No,
they
you're
asked
just kind of
that,
like
but-
playing devil's advocate, I know, but like,
And music is more than just the sound of the music, it's rhythm, it's, you know, you can, like you say, like words can
conveying meaning, yeah.
chorus teacher would be absolutely.
Oh, you never know.
We do sign language in our chorus, so, you know.
But no, I thought about that. So, I mean, that's a valid point to bring up. It is.
The chorus teacher at my kids' elementary school, they have a lot of disabled children in that school.
And she purposely like makes sure to include all of them, and the concerts are so lovely because even kids with, you know, hearing impairments or all sorts of disabilities are involved and can play, you know, the little, I don't know, shake the maraca or whatever, and it's delightful. It really expands music, in my opinion. But I'll fight for you if they try to not let the kid. I mean, it's so crazy. I could see as if, you know, maybe it's a high school and it's a competitive course or something like that, like maybe. But I would think, especially for the younger ages, there should be a participation thing. I don't know. Personally, I see this all having a positive impact. I mean, I've advocated for my younger kid who has some issues, and it's interesting to see like the schools sort of are being impacted whether they like it or not. Like they're thinking differently. Like they tried to deny my kid to go on a field trip because he had a bad grade on his report card, and I was just able to talk to the assistant principal and say, you know, he's doing his best, there's no behavioral issues, this is an educational field trip, and they immediately said, no problem, he can go, you know what I mean? So, I mean, I don't know, I'm seeing some positives, I hope you guys do too. I know you deal with the people who are struggling, but I do think it's having an impact, I certainly hope so.
Well, it's good for the non-impaired to, you know, see, because these people are going to be in the community and around, so, you know, it's a positive thing for everybody.
You know, music can be very therapeutic, and just like, even if you can't hear or you can't speak, there's something even to music therapy. And I have a child, I'm a volunteer, I have a child who has a speech impediment. She can hear,
Right,
but
like
she
the
can't
child
communicate very well. And I've taught her little ditty songs, and her language is impeccable. When she's singing, she's very clear, and it's just amazing. Even if it broke down the words in the song without the beat, she has trouble pronouncing those words. I talked to her speech therapist about it, and so, you know, it just kind of opens up that whole world about how you think about things and the effect on children. And so, you know, I would be an advocate for making sure we find out whatever we can do to make this child inclusive. I mean, it doesn't say anything about his or her hearing.
Yeah,
It says
he can
speech and
actually hear.
language.
Yeah.
So, you know, the child may have full hearing, but has trouble communicating with others through speech patterns. So, my 2 cents worth.
Well, you know, there's people who have a stutter can actually, when they sing,
Yeah.
they don't stutter. And so actually music can be used. I have a degree in speech also, and I was just being a fly in an ointment. That's just wanted to bring it up. But it really is, this could really be of assistance to her.
Yeah.
Because once she starts singing, the language will come out much more smoothly, just
Right.
as for a stutterer.
Right.
It's amazing, when they start to sing, they do not stutter, because it comes from different parts of the brain. So it's interesting.
Yeah, like I was nervous for this presentation, but if I had to sing in front of you guys, I'd be fine. But yeah, it's a big difference. What? I could do it by myself. I could do that. I've done that. Okay, well, good. I'm glad that this one, you know, sparked some thinking and a little bit of debate. I feel like I did my job. Okay, hypothetical 3. This is a very common fact pattern that we see. An after-school program in Sunshine District has a policy that a student must be able to appropriately behave according to its code of conduct in an environment where supervision is provided at a 1 to 25 adult to students ratio. A student with an IEP for autism spectrum disorder and language impairment is suspended from the program due to disruptive behaviors such as elopement and throwing objects towards others. So what would we do in this situation?
I would use the IEP, number 1, number 2, Title II, and this is really funny because that's the exact language in my son's after-school program,
Oh, yeah.
and my son is on the spectrum.
Yeah.
And so we had a little bit of fun with that.
Yeah. Definitely, I would say look at what I try to do with these cases. Even though we're focusing on the after-school issue, there may be some deficits that the school isn't addressing on the IEP. So definitely, request records to look at the behavioral data and to see if there's an FBA and a BIP on file, and if not, work with the school to get one, and maybe he can generalize those skills to the after-school setting. And I've had situations where the teacher or the behaviorist will kind of create a little mini behavior plan for the student, so to participate in the after-school program. These behaviors such as elopement and throwing objects towards others, if you're doing an FBA, you're kind of trying to figure out the function of the behavior. Why is he doing this? Is this a direct threat? Have we tried to mitigate this? Have we put in an extra pair of eyes, ears, hands? To try to mitigate those behaviors, which they're.
There could be even like a training issue, say you can de-escalate or you can escalate depending on how you approach a specific child. And so to know that specific child and how best to interact with them. I think there's so much you could do with that, but that hypothetical, I think we see that all the time.
Yeah, it's they violated the code of conduct, they've been written up 4 times, we're kicking them out. And also this 1 to 25 ratio, when I was doing my research, is something that I want us to kind of look at. It discourages parents with disabilities because they see that and they're like, oh, well, my child isn't qualified, and that's not true. Yeah. So that's problematic. So even if the policy says that, they can say that all they want. They really shouldn't, but they really should try to accommodate. And if a 1-to-1 aid is necessary, I would argue that they're federally mandated to provide it. It would be hard for them to argue that it's an undue burden or a fundamental alteration. All right, well, that's it. Here's some resources that I've put up for you guys. You can go to the ada.gov if you want to file a DOJ complaint, OCR to file an OCR complaint. Florida DOE has a lot of good technical assistance papers. Rights Law is a good resource. And we're a good resource. You can contact us. You can look on our website. We have lots of good information there. If you have any questions or you have a client or someone in mind that you want to refer to us, just have them call us. Our intake, we have a really good intake department who will screen your needs, and if it's something that we can assist with, they'll send on. If not, they'll provide you really good information and referrals to get you where you need to be. Yes, I do actually. I'm based out of Tallahassee. My supervisor is in South Florida, and like I said, we have offices in Gainesville and Tampa, and then we have some satellite offices, and we're all over. Even though I'm in Tallahassee, I might have a case in Brevard or Hillsborough or Collier or something. So we're all over, and we're free. Our services are free. Yeah. And we have attorneys and advocates.
I wanted to ask, so as a guardian ad litem attorney, we get our kids with, disabilities all along the spectrum of disabilities.
Right.
And so there are times when stuff happens and we're like, well, I'm not too sure about that question. Is that something that you all, if we picked up the phone and called you, would you be able to help
Yeah.
handle? Okay,
Yeah.
thank you.
Yeah, definitely.
Yeah.
Yeah, if you called and requested.
They're
Sure.
doing a little bit of monthly stuff like on our monthly calls, but I feel like sometimes there's areas that we're not quite there yet, and sometimes something will pop up. We had a kid not so long ago who was restrained, pinned down with his arm and his back on the ground at a special needs school in Wabasso because he had a meltdown, and he was later kicked out of the school, and so we were trying to work with least restrictive and everything else and trying to figure out what we needed to do to get him back in. But he's back in school now, but it was after that entire ordeal, and he's got a list of, just a flowing list of disabilities.
So for instance, for things like that, one would be technical assist, two, we can take the case and advocate for the child, and appropriate services, and we are also available to do trainings to you all anytime.
Obviously, certain children with disabilities
by law get an attorney ad litem, and of course we have in each county, people who do that, but they're not always versed in real disability issues. Do you guys take those, like represent those children in dependency cases, or would you have people you could recommend in a specific case, if a child had specific, special needs or whatever, and we're looking for an attorney who has maybe more knowledge and ability in that area? Because I think that sometimes they get an attorney ad litem appointed, but they don't always have the correct skill set to properly advocate for the child. So I just wondered if you guys were a resource in any way to help us in that area.
Being that I was a former attorney at Litem, that I was appointed onto, I was actually appointed through the dependency court, not obviously through your program, although in law school it was at I was part of your program. But I used to work for legal aid, and a lot of the legal aid corps in Florida have education programs where in dependency court an attorney ad litem can be appointed to represent the child's educational needs. In cases where that's not available, yes, we can be a resource there and assist in either A, providing technical assist to the attorney ad litem, or B, taking on the education case if it comes to a level that, technical assist would obviously not support them enough. So yeah, we do, and we are available. So I was joking yesterday at the meet and greet that I felt like a walking commercial, because I was trying to get people to know, yes, we're a free resource to you all. So for the children in care, and honestly for your family members too. So.
I just wanted to piggyback off of what she said. I actually am a special needs education attorney with legal aid in Broward County. So specifically in situations like this where there is a behavior or a child is suspended or the school wants to do a change of placement based on the behavior, a lot of times what we'll do is we'll come to the forefront to have a manifestation hearing, or even before that point, a conference with the school to see if the child's behavior was a manifestation of their disability, and if so, at no point whatsoever would the school then be able to suspend or try to change the placement or do anything to keep that child from attending that school based off of that behavior.
All right. Thank you so much for coming. Thank you. Hope you learned a lot.